to expound on things. That's not misconduct, and it certainly isn't Mr. Hupp's misconduct. The claim is that somehow there was a violation of the appearance of fairness doctrine. Your Honor, you and I have done enough land use cases together where we're familiar with the appearance of fairness doctrine. It applies to quasi-judicial hearings. Things like the hearing examiner, things like a planning commission. It does not apply to receiving comment on a proposed lease document. That is an administrative and, if anything, legislative function, not a quasi-judicial hearing process. The appearance of fairness doctrine, which is the standard that's been cited here for why this is misfeasance, simply does not apply as a matter of law. And so that charge is legally insufficient.
Okay. So what I hear you saying is on August 3rd, they asked people make their comments, and then what I hear the word used is filter out. Is that correct?
I don't recall anyone using the words filter out, but what they asked them to do was speak to the specific provisions of those lease documents that were the subject of that public meeting. The whole purpose of having the public come speak was to inform the commissioners as to whether or not they should make changes to that lease to protect the public's interest. And that's why they had that meeting, and they had several hours of people coming forward and actually discussing it. And, Your Honor, at that meeting, there were speakers set up. Your Honor talked about having a satellite dish. They didn't have to go to a satellite dish. They just ran some speakers outside, set up a tent where the overflow could be accommodated. No violation of the Open Public Meetings Act. Everybody who wanted to speak and listen.
No. Are you telling me that the overflow, in fact, indeed got to hear what was being said?
Yes, Your Honor. That's what Mr. Hupp's declaration says. That's what Mr. Hauser's declaration says.
I've got the Hauser Declaration. You tell me where it says that.
I believe it says it in Mr. Hupp's declaration. On paragraph 9 on page 4 of Mr. Hupp's declaration, talks about the loudspeakers that were set up to provide for the overflow.
Okay, number 9. May I take a moment? All right. So what happened on August 3rd? He suggested it that if there is an overflow on August 16th, that they just filter out. But that's not
what actually happened.
What occurred on August 16th? Is that when the speakers?
That's when the meeting was actually held. There were loudspeakers set up. There was a tent outside where people could sit outside in the sunshine and listen, rather than sit in the hot hearing room. And people could come and go as they pleased, but nobody was ever asked to leave. There's not any indication or evidence to support that. There was an accommodation made for an overflow crowd. The other thing that happened at that meeting was everybody got to go around once, and then they took a break for lunch. And after lunch, people came back and were offered an additional opportunity to address the commissioners for 1 minute each if they so chose. So the commissioners here absolutely discharged their duties properly, in conformity with the law, and there was no violation of the Open Public Meetings Act.
Okay, so let's go back. So you're saying at the special meeting of August 16th, you are now telling me that there was a basis for the public to hear what was being said, and that was speakers in outside so that all could hear. Is that what happened?
That's correct, Your Honor.
And I have that in the declaration of Mr. Hupp, and I'm looking at the declaration of Hauser. Where do you see that?
Mr. Hauser's declaration, I don't think addresses the loudspeakers in the overflow.
Okay, where does it address it in this year declaration again? Number 9? Because I don't see it in number 9.
In Mr. Hupp's declaration, paragraph 9,
Page
4, line 17. Indeed, prior to the meeting, the court arranged for loudspeakers to set up in an overflow area so that the public could listen to comments if the room exceeded its capacity. Some of those testifying stepped outside where the shaded tent and speakers were in order to be more comfortable in the heat. However, no citizen was asked to leave during the meeting. Mr. Hauser's declaration acknowledges that he was the one who was presiding as a pro tem parliamentarian at that meeting. And that's on page 3 of his declaration at lines 20 through 23.
Okay. All right, so that is allegation number
That's allegation number 4.
4.
Allegation number 5, we got to go back to July 31st, 2010, where Commissioner Hupp is alleged to have violated his oath by excluding Commissioner Miles in an illegal email.
And that is the email that you have referenced already.
That's the one I referenced already, which wasn't sent by Mr. Hupp. It was sent by Mr. Dobson. So the conduct here isn't Mr. Hupp's conduct, it's Mr. Dobson's conduct. It's factually insufficient to allege an action. And I think there was some great confusion as to exactly what it was that was being alleged here. Is it the adoption of Resolution 10-2? Or is it the sending of an email? And the July 31st email is not sent by Mr. Hupp. It's sent by Mr. Dobson.
I'm going to give you time to, it does seem to indicate that, counsel, that it came from a jd@portshelton.com. So I'll give you that when you come back. Please address that. Thank you. Go ahead.
Allegation number 6 is the Public Records Act violation that is alleged. Again, Your Honor is absolutely correct. This is not the way you review a Public Records Act. If you disagreed about whether something is or is not properly redacted, there's a different form for that, not a recall. And the records that were provided here are personal cell phone records, not records of the court. They're not public records because they're not prepared, owned, used, or maintained by the court in any way. The court doesn't pay his cell phone bill. And actually, it's Mrs. Hupp's cell phone bill, which is why the name is redacted next to the bill on the front page. This is just legally insufficient to state a violation. And if anybody violated the Public Records Act, the duty under the Public Records Act falls on the agency, not Mr. Hupp as a commission, as an individual. So there is no basis here here for a violation. Allegation number 7. If you're ready to move on.
I am.
Allegation number 7, again, is the failure to properly keep minutes. Two commissioners voted on the 21st to approve the minutes.
The 21st of what date?
I'm sorry, the 21st of
August.
September. They voted to approve the minutes of the September 1st special meeting, which was a meeting that was held between the court and various officials of other agencies and jurisdictions here in Mason County. The county was present, the PUD was present, the city of Shelton were present. And they discussed matters of interest for all jurisdictions. And that's what the minutes say they discussed. There was some